Hi, my name is Lisa DeMoss. I am the director of the Western Michigan University Cooley Law School graduate program in insurance law. And on behalf of the program, I am so pleased to welcome here today David Kramer. David Kramer is an attorney and also a partner in Gemini Risk, a professional liability insurance brokerage firm. And so David, thank you for joining us today.
Thanks for having me.
It's our pleasure. Could you tell us a little bit about your career trajectory? How did you move from law school to owning and operating a professional liability insurance firm?
Sure. I grew up in a family of lawyers. My grandfather was a lawyer, my father was a lawyer. So for me, I didn't really think anything other than to go to law school. Went to law school. Ended up, fortunately, going to law school at a time when the economy was good and I had some career options, and I went to work for a large law firm in Washington, D.C. And then I came back to Michigan and worked here for law firms and realized about 6 years into my career that I didn't want to practice law for a living, but I really didn't know what my options were. All I knew was law. I was a little worried about taking that investment in law school and my legal degree and doing something else. And I just started talking to people and having an honest conversation, saying that I was interested in doing something different, and talked to a number of people in different fields, banking, for example. Ultimately talked to someone in insurance who talked to me about working with lawyers and law firms and representing them, and kind of using my legal background to help those firms avoid risk and give them a little bit of comfort that I'd been in their shoes before. So I transitioned into insurance about 14 or 15 years ago and haven't looked back.
Terrific. So did you practice insurance law before you went into the industry?
No, to be honest, I knew next to nothing about insurance. I practiced transactional law, did corporate work, I did a little bit of bankruptcy work, some real estate work. The only thing I really knew about insurance and how it affected law firms were the conflict checks that I would see going around to our firm that I kind of just looked at for all of 10 seconds. So this was all totally new to me.
Sounds like an exciting adventure.
Yes, definitely.
All right. And so tell us a little bit about what an insurance brokerage firm offers by way of products.
So there's kind of a differentiation between a general insurance firm and a specialist firm. So at a generalist firm, they can offer products to just about anybody for all different types of risks. The advantage of that is there's kind of a wide breadth that is offered. The disadvantage is kind of the old adage about being a master of none, kind of doing a lot of things but not doing them all that well. Specialist brokers that work with law firms tend to be a little bit more laser focused on the risk, have a little bit better understanding of what law firms deal with. They may not be able to handle absolutely all types of insurance, but they certainly have a lot of experience working with law firms. At our firm, we really specialize in working with law firms on the coverages they need, and the coverages that they need most basically are lawyer's professional malpractice. If they have their own firm, then they're going to need property and liability insurance to cover the firm, workers' compensation insurance, which goes along with that. And then depending on what their risk appetite is, there are other products that law firms may or may not buy, such as employment practices liability that would cover a firm from allegations of harassment or failure to promote, sexual discrimination, etc. Management liability, which operates sort of like a D&O policy for lawyers and law firms. And now the newest product that's out there is cyber insurance. And I think we'll talk about that a little bit later when we talk about kind of new things in the industry. But that's certainly a line of coverage that I think more and more lawyers are looking at pretty seriously, and most law firms will buy in the coming years.
And so what, if anything, did you need to do to enter into an insurance brokerage line of work? Did you have to go back to school? Did you have to become certified or licensed as a broker?
I had to become licensed. I had to go to a course, which was, I believe, a week-long course in East Lansing. And I have to say, coming from law and having studied and sat for a bar exam, the prospect of taking an insurance exam was not all that daunting. And though I was in a class with a number of people who were really nervous about taking the exam, law school and the rigors of the bar exam definitely, and final exams in law school, really prepared me well to do that. So it was not a tough barrier to entry from a lawyer's point of view.
So if I were a lawyer starting a new firm, would I come to Gemini for advice, or how would I go about the process of identifying and procuring the risk protection that my new business needs?
Right. So first of all, lawyers' professional liability is not totally required by the state of Michigan, but it is, in my opinion, essential to have. So the first thing is, if you're starting a practice, you should absolutely get malpractice insurance, and you should obtain it prior to even practicing. There are a number of vehicles to procure the insurance. As I mentioned before, the specialist brokers, I think, offer the most knowledge in this area and have access to the insurance companies who write this area. It used to be that the insurance companies who wrote Lawyers Professional were big multi-line insurance companies that you hear of often: Hartford, Travelers, Fireman's Fund, etc. Those companies are smaller players in the industry now. Now the industry is dominated by more specialty players, and the specialty insurers are represented by the specialist brokers. So it's important to go to a specialist broker. Obviously, we would love to help whoever's watching this at Gemini, and feel free to contact me. There are a couple others in Michigan who really do have a focus on Lawyers Professional and know how to handle it well. So you would contact one of us for starters. The process is to fill out an application that typically ranges from 2 or 3 pages to maybe 10 or 15 pages. The application asks questions about risk controls. So it'll ask things like, are you going to have a docketing system? Are you going to have a conflict of interest software program or some sort of conflict check? Are you going to require engagement letters when you take on a new client? Then we'll ask about areas of practice, because insurance companies, when they're rating up a law firm, look at what areas you're in. Certain areas are considered more risky than others, and therefore the price is higher, and some insurance companies won't even write insurance for lawyers doing certain types of work.
Could I stop you right there and ask you?
What are the,
everyone's intrigued.
Right.
Now, what type of high-risk activities draw or require a greater premium, or perhaps the possibility that you have to self-insure?
Sure. So there are areas of practice that are high frequency of claim areas, and then there are areas of practice that are high severity, maybe low frequency but high severity. So the high frequency but potentially low severity areas are areas like consumer collection law, where lawyers get sued often for violations of the Fair Debt Collection Practices Act. Some plaintiff work. There's kind of a common thread, and I think we're going to talk a little bit about risk management later, but there's a common thread of smaller, unsophisticated clients tend to cause more trouble for lawyers. So any area of law where you're dealing with kind of the person off the street tends to promote more claims. So auto negligence is a frequency area, not necessarily a severity area. So those are areas that insurers will want firms to take a high enough deductible that they are not getting nuisance claims for $1,000 or $2,000. The high severity areas where you can have infrequency of claims, but when the claims hit, they can be quite large, are areas like intellectual property, where if a deadline is blown on a patent, the inventor is going to claim that it was the next iPod or the next cancer-curing drug and worth tens of millions of dollars. So that can be worrisome to insurers. Securities law, which there's not a lot of in Michigan, but those, particularly if you're dealing with public offerings, can be worrisome. Larger corporate transactions, just because of the dollars involved, can be worrisome. Doing work for high-profile clients, entertainment clients, can be worrisome. Class action plaintiff, just because if you have a problem, there could be thousands of plaintiffs that are suing you in turn. Those are some of the areas that are of most concern.
So I interrupted you, but we were talking about the applications that
Right.
are required to initiate the process, and I'm wondering, if I'm starting a law firm and I'm looking at the application form and I have to answer no, 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 because I really don't have any idea about how to structure my office, well, what do I do at that point?
Right, and that's a common question. For example, also in the in the application, it asks what your areas of practice are going to be, and to break those areas of practice down to a percentage that equals 100. And oftentimes, attorneys who are starting in practice say, look, I'm open to taking a number of different things, and I can't tell you with specificity that my practice is going to be 25% domestic relations or 40% labor, nor do I know for sure whether we're going to have certain systems in place, et cetera. I think the misconception with these applications is that you just have to check a yes or no and there's no other answer. I think the best advice I could give someone starting out is, if you are filling out an application, feel free to say, see attached, and put on a separate rider or even in a cover letter, I'm starting my practice, this is what I expect, the application is kind of my good faith guess of what practice is going to look like, but at this point it is sort of an educated guess. And the insurance companies understand that practices evolve and that you don't always know on day one what it's going to look like.
And so they submit the application, and you as a broker go into the market and try and identify an appropriate policy, or how does that work?
Right. So there are a number of insurers that will look at firms. Typically, actually, smaller firms of 1 or 2 attorneys have a more limited marketplace, simply because some insurance companies have decided that the limits that they're putting out and the exposure doesn't equal the small premium that they have to charge for it. But there are a handful of insurance companies that will look in a small law firm in Michigan or other places. They typically would quote within a week or 2 weeks, so it's a fairly quick process. The question at that point for the law firm is what type of limits do you want to buy, and what kind of deductible structure are you willing to take on. The insurance companies like to see that you've put some skin in the game. So as I said, you're not sort of swapping dollars with them on nuisance claims. So the higher the deductible, the more attractive it is to the insurance company. Arriving at limits is more art than science. I think it comes down to what is your area of practice, what is your risk tolerance, what, of course, is the cost and kind of cost benefit. I think it behooves firms starting out to look at what are the range of options available. Typically, a solo practitioner would look at least $500,000 of coverage, probably more like $1 million. And the reason for that is because the vast majority of policies include defense costs within the limits of liability, which means that if you get sued, your defense bills erode the limits. So we have seen many, many claims where the allegations were frivolous, and in fact no payment was actually made at all, but the defense costs still were in the hundreds of thousands of dollars. In some cases, we've actually seen 7-figure legal bills where the end result was no liability at all. So it's important to not look at limits as just, well, what's my maximum exposure if I screw something up? It's that, then backing out defense costs.
We tend to forget as lawyers that when we get into a bind and we're sued, that it's always prudent to hire an attorney or have our insurance carrier hire an attorney rather than trying to defend yourself.
Right, whatever the adage is about having yourself as a client makes you a fool, something of that variation. I think that's true. And actually, more importantly, insurance policies typically will require the insurance company to handle the claim, and they're going to hire an attorney that they're comfortable with.
Right. So does the brokerage firm provide advice to the applicant, I guess, with regard to liability limits by providing, I don't know, market averages, or how? I think that's very perplexing to me in terms of how much do you need?
And again, this will sound a bit like an advertisement, but I think the specialist brokers do a much better job of being able to render advice on questions like this than the general broker who just hasn't seen as many law firms and worked on as many law firms. But there are not, unfortunately, there is not a lot of publicly available data out there on limits of liability, claims, etc. So for us, we really go on benchmarking of our own clients, anecdote, kind of just what we're hearing from the markets, and a little bit is sort of feel. But in talking to someone, we can get a pretty quick sense based on what they're planning on doing of what the right limit range is, and then we can look at pricing. One thing that's, I think, important for lawyers starting out to remember is lawyers' professional is written on a claims made basis rather than occurrence basis. So what that means is that The policy that responds is the policy when the claim is tendered to the insurance company rather than when the alleged malpractice occurred. And the reason that's important is because as years go by, the body of work that you could be sued on becomes greater. And in consequence, the insurance company will actually charge more typically in year 2 and year 3 than they will in year 1. In year 1, they're basically betting on the fact that the odds that you're going to make a mistake and someone's going to sue you for that mistake all in the same year are a lot less than in year 2 and 3, etc. So price goes up for a few years after year 1. So when you're looking at the startup cost in year 1, you need to understand that that's not likely to be cost in year 2.
And then how does a claim actually impact your future premium and expense?
To some degree, it sort of works like any other type of insurance. A claim, you are still sort of a spreadsheet to some degree to an insurance company, and they're looking at what they call a loss ratio. How much did you pay in versus how much have they paid out? So a claim affects your premium quite a lot. That being said, I think that a good broker as an advocate can help differentiate you, or at least a good firm, from a firm that maybe takes risk management less seriously. So if firm A has a claim for $100,000, but that firm really has good controls in place, and the claim was more a product of just sort of happenstance, and firm B has the exact same claim but really doesn't have the same investment in risk management and seems more likely to have a repeat claim, firm B should be penalized more severely than firm A. Doesn't always work that way, but I think in theory that's the way it should work.
So could we switch gears for a second and talk risk management?
Sure.
You've identified some aspects of a control environment. How does your brokerage firm engage your clients, the purchasers of your services, if at all, in risk management activity?
We do so to some degree on a proactive basis and in some degree in a reactive basis. The reactive is that we field a lot of calls from our insureds asking us questions like, can you look at our engagement letter and let us know if it's adequate? We have a potential situation, it may or may not be a claim, we want to talk through it with you. We're looking into how to best store documents. Should we store them on the cloud? Should we use a third-party vendor? What are you hearing? What's kind of best practices? So I think a good broker knows how to handle those questions, and a smart insured knows to reach out to their broker to ask those questions. Proactively, we try to disseminate a lot of information that we find from our insurance company partners, or that we've read in trade periodicals about kind of best practices and things that are going on. We do a lot of speaking to our law firms. We do lunch and learns on kind of lessons learned in claims. We speak at conferences and forums. I think coming from law school and being an advocate in my former life, what is the most important service we can provide are those kinds of services, rather than showing up once a year and saying, here's your insurance renewal premium.
So let's talk about best practices for a second. What are some of the tips, a couple of tips that you might share with the viewers regarding a better control environment, if you will, with regard to the operation of a law firm?
If you look at all the claim statistics from different insurance companies, the ABA, et cetera, the statistics are sort of all over the map in terms of where claims come from. But the one thing that you can certainly conclude from all those studies is that probably 50% or so of claims are theoretically preventable. And I think that the vast majority of them are preventable right at intake. If there's one takeaway in risk management, it's be very diligent at intake. And I define intake as setting expectations with a prospective client, making sure that they understand what the process is, what it's going to cost, what the likely outcome is, making sure that you have a good engagement letter with the client that really acts as a roadmap and talks about what you've been engaged to do, who the client is and who they are not, particularly in a corporate situation where maybe your client has affiliates or subsidiaries or related companies, to define that you're not doing work for them. To define the duration of the matter, to specify what client duties are imposed on the client, timely payment, letting you know if an address changes, etc. So really reducing to writing the engagement. to making sure that you understand the ethics laws with respect to conflicts of interest and that you don't run afoul of those. That also, to me, is an intake issue. And that if you have things that are date intensive, whether it's litigation or something like intellectual property, that you really have a good system to manage it and ticklers and that you're not missing dates. Then the final thing I would say is really good documentation and with clients and also in your file and client communication. It's amazing how many times we see claims that would have totally been avoided or would have been totally defensible if only the lawyer could have pointed to an email or a document or a note in the file saying, we talked about this and decided to do X rather than Y. Because it always ends up being the lawyer's fault. The client always says, you should have told me X, or you told me X and you should have told me Y. And the lawyer always says that's not true, but if they can't point to something in writing to evidence that, it's a much tougher hurdle.
Those are great tips. What about hot topics? What are some of the challenges out there? I think you mentioned cybersecurity earlier. Could you amplify on that?
Sure, that's certainly number one. Insurers that write lawyers' professional liability are very interested in firms' cybersecurity controls because, after all, if you lose client data, for example, if there's some sort of loss to your client because of something that is cybersecurity related, they're going to sue you, and they're going to sue you for legal malpractice. So there's a direct nexus between a legal malpractice claim and good cybersecurity practices. And in fact, the ABA has set a reasonableness standard for making sure that you're current on cybersecurity standards and code of conduct. So that's very big in the lawyer's professional context. Outside of the lawyer's professional context, cybersecurity is being talked about because there's a whole area of exposure to lawyers that is not covered by lawyer's professional or, frankly, any other policy, and that's what we call first-party exposure. So that would be things like costs that you incur to have to do some sort of forensics analysis if your systems get hacked into or are down. The ransom payments that you may have to pay to someone who extorts your data. The business interruption issues that you may face if you just can't get into your system for several days. And if you think that doesn't happen, DLA Piper, which is the largest law firm in the world, was locked out of their systems for several days. So if it can happen to them, it can happen to you. There are some sort of variants of that, like these phishing schemes where people will send you an email that you'll click on and they'll get into your system and be able to compromise your data. Or what we call social engineering, where there'll be an email that looks like it's from a client or a colleague of yours asking you to wire money to a certain person or to do something that causes you to part with certain assets when it turns out that was an impersonator. All those things are not covered by normal insurance, and so it's important to talk to a broker about covering all the different cyber exposures that are out there, many of which I think we're still trying to kind of understand ourselves, so it's a little bit scary.
Any other hot topics besides cyber insurance that you see looming on the horizon?
I'm seeing more and more law firms, particularly ones that have several employees, getting serious about employment practices coverage, particularly with everything that's happened in the news in the last year. I think it's important to make sure that you have proper coverage for claims of harassment, claims of discrimination, for even claims of failure to promote. A good employment practices policy for a law firm will recognize that there can be a loss and a claim related to not making someone a partner or not promoting someone from clerk to lawyer. So those policies are becoming more and more in vogue as well.
There's a lot of risks to be mindful of.
Yeah, sorry to depress everyone.
Anything else you'd like to add about the brokerage business or risk management? Or
I guess the only other thing I would add is feel free to use me as a resource, even if you're not a client. I've had the shoe on the other foot, and so I like to be helpful. My colleague actually used to defend lawyers for a living, and so he and I field a lot of calls from people who aren't clients just asking about tips on how to procure insurance or risk management, and we're always happy to help.
great. David Kramer, thank you so much
Thanks
for
for your
joining us
time. I
today.
appreciate it.